It is 2:14 a.m. You are the overnight hospitalist covering a 28-bed service. The emergency physician calls with an admission. A 54-year-old man with substernal chest pain. Troponin negative ×2. Heart score of 3. Low risk. The ED wants to admit for observation and serial troponins. You push back. The heart pathway literature is clear. A score of 3 or below with 2 negative high-sensitivity troponins identifies patients at less than 1% risk of major adverse cardiac events at 30 days. The evidence supports discharge without patient follow-up, not an inpatient admission that exposes the patient to hospital-acquired risk and the system to unnecessary cost. You discharge the patient. You document your reasoning. Heart score, serial troponins, risk stratification, shared decision-making, return precautions. 6 weeks later, the patient has a myocardial infarction. The family sues.
Under the old legal framework, the central question would have been simple. What do most hospitalists do with a heart score of 3? And if the customary practice in your region was to admit and observe, you lose, even though the evidence was on your side.
Under the 2024 Restatement of the Law, 3rd, torts, medical malpractice, the question shifts. And a provision most physicians have never heard of, Section 6b, may hand you the strongest defense tool in modern malpractice law. This is the Charted Defense. I am Brian.
I am Sarah.
And I am Michael Coleman. Today we are going deep on a single provision of the 2024 Restatement, Section 6b, the asymmetrical shield, how it works, why it only runs in one direction, and the 3 defense pipelines it creates for every physician who documents their clinical reasoning.
Before we go further, what this episode covers and what it does not. In our previous episode and newsletter on the Restatement, we covered the headline shift from custom to competence under Section 5, the elevation of evidence-based medicine, informed consent reforms under Sections 12 and 13, the lost chance doctrine under Section 8, and institutional liability under Sections 14 and 15. If you have not read or listened to that piece, start there. It provides the foundational context for everything that follows today. This episode narrows to a single provision, Section 6b, and its strategic implications for your defense if you are ever sued.
A few critical framing points. The Restatement is persuasive authority. It does not automatically become law in any state. No court has applied Section 6b as binding precedent. The defense pipelines we described today are analytical constructs, logical applications of Section 6b, combined with existing procedural mechanisms like summary judgment and Daubert motions. They represent what is strategically available under the Restatement's framework, not what has been tested in court. That said, the gravitational pull is real. The Texas Supreme Court cited Section 5, A in a 2024 opinion, and Section 15 in 2025. The United States Supreme Court cited Section 11 in March 2026. Courts are paying attention, and the defense bar is already studying how to operationalize Section 6b.
Our discussion today draws on the Restatement's approved sections, the ALI's official commentary, the 2025 JAMA synthesis by Aaron, Robertson, King, and Sage, the critique by Stewart and Peck in the American Journal of Law and Medicine. They called it A Bridge Too Far. Hall's published response defending the provision, and recent Alabama Supreme Court decisions including Ex parte Stephen M. Taylor, MD, and Hickson versus Premier Medical Group, both from 2025.
Section 6 of the restatement addresses how breach of the standard of care is established. Most of the attention since May 2024 has focused on Section 5, the shift from custom to competence. But Section 6b may prove more consequential in the courtroom. Sarah, walk us through what it actually does.
Section 6b creates what I would describe as an asymmetrical evidentiary rule, and it is the most debated provision in the entire restatement. Here is how it works. For defendants, compliance with an authoritative clinical practice guideline can serve as prima facie evidence of non-breach. If a physician followed a guideline that is methodologically rigorous, evidence-based, and issued by a recognized medical body, that compliance alone can support a finding that the care was competent, even without additional expert testimony on that specific point. For plaintiffs, non-compliance with a guideline does not receive the same treatment. A plaintiff cannot point to a guideline the physician did not follow and use that non-compliance as standalone prima facie evidence of breach. They can introduce guideline non-compliance as evidence, but it must be established through the traditional mechanism. Qualified expert testimony explaining why the deviation fell below the competence standard.
So defendants get a procedural shortcut. Plaintiffs do not.
That is exactly the criticism. Stewart and Peck, writing in the American Journal of Law and Medicine, called this provision novel and unprecedented. They argue it creates an unfair procedural advantage for defendants and potentially conflicts with existing evidentiary rules governing the admissibility of guidelines in court.
Let me put that in clinical terms. If I follow the heart pathway protocol, document it, and the patient has a bad outcome, under Section 6b, my attorney can present that guideline compliance as standalone evidence that my care met the standard. That is a powerful starting point, but if a physician ignores, say, the ACCP guidelines on anticoagulation for pulmonary embolism, the plaintiff's attorney cannot just point to those guidelines and say, he did not follow this, therefore he breached the standard. They still need an expert witness to build that case through traditional testimony.
Hall, one of the restatement's reporters, defended the asymmetry. What was his argument?
Hall's position is that authoritative guidelines represent the collective judgment of the medical profession, distilled through rigorous methodology. Allowing them to serve as prima facie defensive evidence reduces the noise of partisan expert battles and aligns malpractice law with evidence-based medicine. The asymmetry, he argues, is intentional. Guideline compliance is a positive act demonstrating competence. Non-compliance has too many legitimate explanations: patient-specific factors, resource constraints, evolving science, clinical judgment, to function as standalone proof of negligence. The universe of reasons a physician might appropriately deviate from a guideline is vast. The universe of reasons a physician might appropriately follow one is straightforward.
And honestly, from the clinical side, that logic tracks. I deviate from guidelines constantly, not because I am being negligent, but because the patient in front of me does not fit the guideline population. A guideline that says anticoagulate all PE patients does not account for the patient who is actively hemorrhaging. A guideline that says admit all troponin-positive chest pain does not account for the demand ischemia troponin leak in a septic patient where the primary treatment is antibiotics, not a cardiac catheterization lab. The fact that I did not follow a guideline standing alone should not be enough to establish breach. I agree with that.
Whether you find the asymmetry fair or not, the practical question for physicians is the same. How do you use this?
The restatement did not just change the definition of reasonable care. Combined with existing procedural mechanisms, Section 6b creates 3 distinct defense pipelines: strategic pathways that convert bedside documentation into courtroom advantage. Sarah, take us through them.
Pipeline 1 is the early disposition pipeline. Here's the mechanism. If a physician's care demonstrably complied with an authoritative guideline, and that compliance is documented in the medical record, defense counsel can move for summary judgment on the breach element of the malpractice claim. Under Section 6(b), guideline compliance constitutes prima facie evidence of non-breach. If the plaintiff cannot produce countervailing evidence sufficient to overcome that prima facie showing, the case can be resolved before trial.
No trial, no jury, no expert testimony fees, no reputational exposure.
Exactly. Summary judgment eliminates the case entirely. For the physician, this is the cleanest possible outcome, but it requires 3 things from you. The guideline must be authoritative, issued by a recognized professional body with rigorous methodology. It must be applicable, relevant to the clinical scenario and the patient population. And it must be documented. The record must show that you knew the guideline, applied it, and that your care aligned with its recommendations.
Let me be concrete about what that documentation looks like. Go back to our chest pain patient. Here is what I would chart. Risk stratification performed using heart pathway protocol. Heart score 3, low risk. High sensitivity troponin negative ×2 at 0 hours and 3 hours. Per heart pathway evidence. Backus and colleagues, Annals of Emergency Medicine, 2013. Updated validation in JAMA Cardiology, 2024. 30-day MACE risk less than 1% in this cohort. Clinical decision, discharge with next-day cardiology, follow-up and return precautions. Decision discussed with patient who verbalized understanding of risk-benefit assessment and return criteria. That note names the guideline, it cites the evidence, it connects the evidence to this patient, it documents the clinical decision, and it documents the conversation with the patient. That is the entry ticket to Pipeline 1.
What is the vulnerability in this pipeline?
Plaintiffs will attack the applicability prong. Was this guideline designed for this patient population? Did comorbidities take the patient outside the guideline scope? Was the guideline current at the time of treatment? The more your documentation addresses patient-specific applicability, the harder that attack becomes.
Pipeline 2 targets the plaintiff's expert witness.
Under Dober versus Merrill Dow Pharmaceuticals and its state law equivalents, trial judges serve as gatekeepers for expert testimony. If a plaintiff's expert offers an opinion on the standard of care that directly contradicts an authoritative clinical practice guideline without providing a scientifically rigorous basis for the departure, defense counsel can move to exclude that expert's testimony. In most malpractice cases, the plaintiff's case rises or falls with their expert. Exclude the expert, and the plaintiff often cannot establish the standard of care or breach. The case collapses.
This is the pipeline that should make every hospitalist pay attention, because what it means is this. When your chart reflects the same evidentiary foundation that authoritative guidelines rely on, when your documentation shows that you were thinking about the evidence, applying it to this patient and making reasoned decisions, it becomes very hard for a plaintiff's expert to credibly argue that your care was incompetent, and it becomes much easier for a judge to look at that expert's contrary opinion and say, this opinion lacks sufficient scientific basis. It is excluded.
What is the vulnerability here?
This pipeline depends heavily on the jurisdiction's gatekeeping standard. Federal courts and states that follow Dober provide the strongest framework. States that still use the older Frye general acceptance standard may be less receptive to guideline-based expert exclusion arguments. You need to know what standard applies in your state.
Pipeline 3 does not prevent liability. It limits exposure.
Section 8 of the Restatement endorses the lost chance doctrine with proportional damages. If a breach is established, damages are calculated proportionally, based on the quantum of chance the negligence destroyed, not the full injury value. Here is why this matters for defense. Thorough documentation of a patient's pre-existing risk factors, baseline prognosis, and comorbidity burden directly reduces the proportional damages calculation. If the record establishes that the patient had a 30% pre-existing mortality risk from their underlying condition, the negligence attributable damages are calculated against only the lost increment of chance, not the full outcome.
This is where severity scores and comorbidity documentation become legal tools, not just clinical tools. Think about an ICU admission. I document an Apache 2 score of 24 on admission. That corresponds to approximately 40% predicted ICU mortality. I document the significant comorbidities: end-stage renal disease on hemodialysis, NYHA, class 3 heart failure with an ejection fraction of 25%, poorly controlled diabetes with a hemoglobin A1C of 10.2. Every one of those documented risk factors reduces the denominator in any future proportional damages calculation. The patient was already critically ill. The baseline risk was already high. If something goes wrong and breach is established, the damages should reflect only what my care changed, not the entire outcome.
An important caveat: the lost chance doctrine is not universally adopted. Alabama, for example, explicitly rejects it. McAfee v. Baptist Medical Center in 1994 established that plaintiffs must prove negligence probably caused the injury, greater than 50% likelihood. The proportional recovery framework of Section 8 has no current foothold in Alabama law. Interestingly, in states that reject lost chance, the traditional all-or-nothing causation framework may actually benefit defendants when baseline risk is high, because the plaintiff cannot meet the greater than 50% causation threshold. So the value of Pipeline 3 is jurisdiction dependent.
3 pipelines, 3 different strategic outcomes, but all 3 run on the same fuel.
Documentation. Every single pipeline starts and ends with the chart.
Before defense attorneys start celebrating, there is a critical limitation. Michael, you hinted at it earlier.
Clinical practice guidelines are population-level tools. They aggregate evidence across thousands of patients to produce generalized recommendations, but the patient in front of me at 2 a.m. is not an aggregate. They have specific anatomy, specific comorbidities, specific social determinants, specific medication interactions, specific values about what risks they are willing to accept.
Plaintiffs will exploit this gap. The argument goes, your guideline was not written for this patient. This patient's specific factor, their renal function, their medication profile, their age, their comorbidities, took them outside the guideline's intended population. Following the guideline in this context was not competent. It was lazy.
This has been called the snowflake effect. The inherent tension between the population-level evidence and individual clinical decision-making. It is the oldest critique of evidence-based medicine, and it translates directly into a courtroom attack on guideline-based defense.
And it is a legitimate critique. I have patients every week who do not fit neatly into any guideline. The 85-year-old on dialysis with a new pulmonary embolism. The anticoagulation guidelines were not validated in that population. The 22-year-old pregnant patient with sepsis. The surviving sepsis campaign bundles were not designed for pregnancy physiology. If I just blindly follow the guideline in those cases without thinking about whether it actually applies to this patient, that is not evidence-based medicine. That is cookbook medicine. And a good plaintiff's attorney will make that distinction very clearly for the jury.
The counter to the snowflake effect is the same answer as everything else in this framework. Documentation. Specifically, documentation that demonstrates you did not blindly follow a guideline. You assessed its applicability to this patient, considered the patient-specific factors that might modify the recommendation, and made a reasoned clinical judgment. The guideline-compliant physician who documents patient-specific reasoning is shielded. The guideline-compliant physician who documents nothing beyond the order is exposed.
Think of it this way. The guideline gets you in the door. The patient-specific reasoning locks the door behind you.
For physicians practicing in Alabama, and Michael, this is your home turf, the restatements provisions collide head-on with existing law.
Alabama is where this gets personal for me. The Alabama Medical Liability Act, the AMLA, codifies the customary practice standard. It defines the standard of care as the level of care exercised by similarly situated physicians in the same general neighborhood. That is the old framework. the one the restatement is designed to replace.
And Alabama courts have repeatedly reinforced that standard. Ex parte, Stephen M. Taylor, MD, in 2025 reinforced the AMLA's rigid procedural framework for expert qualification and pleading requirements. Hickson v. Premier Medical Group in 2025 continued the same trend. Alabama's procedural strictures make it harder for plaintiffs to bring cases, but they also lock in the customary standard in ways that resist the restatement's competence-based approach.
Alabama also rejects the lost chance doctrine.
Correct. McAfee v. Baptist Medical Center in 1994 established the rule. Plaintiffs must prove negligence probably caused the injury, greater than 50% likelihood. The proportional recovery framework of Section 8 has no foothold in Alabama law. Pipeline 3 does not apply in Alabama under current precedent.
And here is the thing, Alabama is not alone in this posture. When the ALI published its restatement of the law, liability insurance a few years ago, several states, Arkansas, Michigan, North Dakota, Ohio, preemptively enacted legislation forbidding their courts from relying on it before it was even finalized. That set a precedent. A similar effort targeting the medical malpractice restatement is plausible. The Alabama Defense Lawyers Association actively monitors ALI initiatives. Organized resistance is real.
So is the Section 6B strategy useless in Alabama?
No. And this is the critical insight. Even within the AMLA's framework, demonstrating guideline compliance is also evidence of meeting the customary standard. As evidence-based practice becomes the national norm, the physician who follows recognized guidelines is simultaneously satisfying Alabama's same general neighborhood test and building a Section 6B record for any future in which Alabama courts or the legislature adopt the restatement's approach.
That is the practical takeaway for Alabama hospitalists, and really for any physician in a resistant state. Build the record as if the restatement were already law. It costs you nothing. You are documenting guideline compliance and clinical reasoning within the existing framework. You are building a defense that works under the AMLA today and under the restatement tomorrow. You are not choosing between two systems. You are building a chart that survives both.
There is one more implication of Section 6B that deserves attention, and it may be the most surprising.
This is the piece that actually excites me. For decades, defensive medicine has been the elephant in the room. We order tests we know are unnecessary. We admit patients who do not need to be admitted. We consult specialists for problems we can manage ourselves. And we do it because we are afraid of getting sued. The standard thinking has always been more is safer. More tests, more admissions, more consultations, more documentation of everything you possibly considered. Cover yourself. But Section 6B inverts that logic. If following an evidence-based guideline and documenting it is a stronger legal defense than ordering every test, then the restatement may actually liberate physicians to practice evidence-based medicine without the fear of litigation hanging over every decision.
It is a genuine paradox. A legal provision designed to strengthen the defense may simultaneously reduce defensive medicine, because the strongest defense is no longer, I did everything, but rather, I did what the evidence supported and I documented why.
Go back to our chest pain patient. Under the old framework, the defensive play was to admit, observe, get serial troponins, maybe stress test, maybe a CT angiogram, cover every possible base. Under Section 6B, the defensive play is to follow the heart pathway, document it, and discharge the patient. The evidence-based decision becomes the legally defensible decision. That is a fundamental shift. It aligns what is best for the patient with what is best for your legal protection. And that almost never happens in malpractice law.
The Choosing Wisely campaign has been pushing this message from the clinical side for years. Stop ordering unnecessary tests. Section 6B may be the first legal mechanism that supports the same message from the courtroom's side. All three defense pipelines converge on a single operational principle. Michael, what is it?
The chart is your entry ticket. None of these strategies work without contemporaneous documentation that connects your clinical decisions to the evidence base. Here's what that looks like in practice. 4 things you can start doing tonight. Number 1, name the guideline. When your care aligns with a recognized clinical practice guideline, say so in the chart. Do not assume someone will figure it out later. Do not assume your order for enoxaparin speaks for itself. State the guideline, name the source, connect it to the patient. Number 2, document the patient's specific fit. When you follow a guideline, note why it applies to this patient. When you deviate, note why it does not. This is the snowflake defense. You are showing that you thought about whether the population-level evidence fits this individual patient. Here's an example. Say you have a patient with an acute pulmonary embolism, but they are also actively bleeding from a GI source. The ACCP guidelines recommend therapeutic anticoagulation with enoxaparin or a direct oral anticoagulant for acute PE. But you cannot anticoagulate a patient who is hemorrhaging, so you document ACCP guidelines recommend therapeutic anticoagulation for acute PE. Guideline not followed in this case due to active GI hemorrhage. Hemoglobin dropped from 12.1 to 8.3 over 24 hours. Melena on exam. Alternative approach, IVC filter placement with plan to initiate anticoagulation once hemostasis achieved. This decision reflects patient-specific risk-benefit assessment, discussed with interventional radiology and GI, patient counseled on rationale. That note is not long, but it does everything. It names the guideline, it explains the deviation, it documents the patient-specific reasoning, it shows collaboration, and it shows the patient was informed. Number 3, quantify baseline risk. In critically ill patients, document the pre-existing risk profile, severity scores, comorbidity indices, prognosis discussions, APACH-2, Charlson Comorbidity Index, baseline ejection fraction, hemoglobin A1C. These are not just clinical tools. In any jurisdiction that adopts lost chance with proportional damages, they become the denominator in the damages calculation. Number 4, build the record prospectively. Do not wait for a bad outcome. Build the guideline compliance record on every patient, because the case that generates a claim is indistinguishable from the case that does not at the time of treatment. The physician who documents clinical reasoning on every admission has a chart that survives scrutiny. The physician who only documents carefully after an adverse event has a chart that invites it.
And I want to emphasize something from the legal side. These documentation practices are not burdensome add-ons to your clinical workflow. They are the clinical reasoning you are already doing. Written down, the physician who is thinking about whether the guideline fits this patient is already doing good medicine. Writing it in the chart is not extra work. It is making your good medicine visible.
Exactly. The restatement is not asking you to practice differently. It is asking you to prove that you practice the way you should have. Show your work.
Let us close with the rapid takeaways. Section 6B creates an asymmetrical shield. Defendants can use clinical practice guideline compliance as prima facie evidence of non-breach. Plaintiffs cannot use non-compliance the same way. This is the most strategically significant provision in the 2024 Restatement for practicing physicians. 3 defense pipelines emerge. First, guideline compliance to summary judgment, early case dismissal. Second, guideline alignment to expert exclusion under Daubert. Collapse the plaintiff's case. Third, documented baseline risk to proportional damages reduction under lost chance. Limit your exposure. All 3 require the same fuel: documentation. The snowflake effect is the counter move. Plaintiffs will argue the guideline was not designed for this patient. Your documentation of patient-specific applicability neutralizes this attack. Alabama's AMLA collides with the restatement. The customary standard, lost chance rejection, and procedural strictures create maximum friction. but guideline-based documentation works within the existing framework and positions you for any future shift. The chart is not just your defense. It is your entry ticket to the defense pipeline. Without contemporaneous documentation of guideline compliance and clinical reasoning, none of these strategies are available. Build the record on every patient. The case that becomes a lawsuit is indistinguishable from the one that does not at the time of treatment. And guideline compliance may reduce defensive medicine. If following the evidence and documenting it is a stronger defense than ordering every test, the restatement may paradoxically liberate evidence-based practice from the fear of litigation.
That is what Section 6B offers. Not a guarantee, not an automatic win, but a strategic architecture, a way to convert the evidence-based medicine you are already practicing into a courtroom defense that works. The chart is the entry ticket. Start building the record tonight.
This has been The Charted Defense. Thank you for listening. If you found this episode valuable, share it with a colleague who needs to hear it. We will be back next week. This podcast is for educational purposes only and does not constitute legal advice or medical advice. The legal principles discussed may vary significantly by jurisdiction. The strategic defense applications described are analytical constructs based on the restatement's provisions. They have not been tested in court as of the date of publication. Case details and legal analysis are drawn from publicly available court records, published legal scholarship, ALI publications, and regulatory documents. Laws governing medical malpractice vary by state. Consult a licensed attorney in your jurisdiction for legal guidance specific to your situation.